Hi, I'm Aloys Hüttermann, founder and partner at Michalski Hüttermann and Partner in Düsseldorf, and you are listening to IP Fridays.
Hello and welcome to this episode of IP Fridays. Our names are Ken Suzan and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
I am Rolf Claessen, and together with my co-host Ken Suzan, I am welcoming you to episode 169 of our podcast IP Fridays. Today's interview guest is Professor Aloys Hüttermann, co-founder of my patent law firm Michalski Hüttermann Partner and a true expert on the Unified Patent Court. He has written several books about the new system, and we talk about all the things that plaintiffs and defendants can learn from the first decisions of the court and what they mean for strategic decisions of the parties involved. But before we jump into this very interesting interview, I have news for you. The US Patent and Trademark Office, the USPTO, is planning rule changes that would make it very difficult for third parties to challenge invalid patents before the Patent Office. Criticism has come from inventor rights advocates. The new rules would play into the hands of so-called non-practicing entities, NPEs, as those attacked would have few cost-effective ways to have questionable patents deleted. The World Intellectual Property Organization WIPO reports a new record in international patent applications. In 2024, around 3.7 million patent applications were filed worldwide, an increase of 4.9% over the previous year. The main drivers were Asian countries. China alone accounted for 1.8 million patent applications, while demand for trademark protection has stabilized after the pandemic decline. US rapper Eminem is taking legal action in Australia against a company that sells swimwear under the name Swim Shady. He believes this infringes on his famous Slim Shady brand. The case illustrates that even humorous allusions to well-known brand names can lead to legal conflicts. A new ruling by the Unified Patent Court, the UPC, demonstrates its cross-border impact. In Fujifilm versus Kodak, the local chamber in Mannheim issued an injunction that extends to the UK despite Brexit. The UPC confirmed its jurisdiction over the UK parts of a European patent, as the defendant Kodak is based in a UPC member state. A dispute over standard patents is looming at the EU level. The Legal Affairs Committee, jury, of the European Parliament voted to take the European Commission to the European Court of Justice. The reason for this is the Commission's controversial withdrawal of a draft regulation on the licensing of standard essential patents, SEPs. Parliament President Roberta Metsola is to decide by mid-November whether to file a lawsuit. In trademark law, USPTO Director Squires reported on October 31, 2025 that a new unit, the Trademark Registration Protection Office, has removed approximately 61,000 invalid trademark applications from the registries. This cleanup of the backlog relieved the examining authority and accelerated the processing of legitimate applications. Now, let's jump into the interview with Aloys Hüttermann. Today's interview guest is Aloys Hüttermann. He is founder of my firm, Michalski Hüttermann Partner, and more importantly for today's interview, he has written several books about the Unified Patent Court. The first one in 2016 already. He is co-editor and author of the standard commentary on the UPC and has gained experience in several UPC cases so far, one even with me together. Thank you very much for being on IP Fridays, Aloys.
Thank you all for inviting me. It's an honor.
All right. Before we dive into the details, how did you end up so deeply involved in the Unified Patent Court, and what personally fascinates you about this court?
Well, this started quite a while ago, more or less approximately 13 years or so, when I became aware that after several other attempts had failed. Finally, there would be a pan-European court and also a pan-European patent. And this time it's serious. And I thought, this is going to be the future. And of course, this interested me both from an, let's say, intellectual perspective, because a new world is built. And maybe one can see how it goes, or even trying to, let's say, work on that. And of course, it was clear for me that this would be a total game changer. At that time, nobody expected that it would take so long until 2023 for the whole system to come in place, but now we have it. But yeah, I already became heavily interested back then. As you already mentioned, my first book, published in 2016, with a clear expectation that the system would come soon, which took a while, but now we have it.
Yeah, before we dive deeper into the UPC, let's zoom out for a moment. If you compare the UPC with patent litigation in the US and in China, in terms of speed, cost, or impact of the decisions, how would you describe the key differences that a business leader should understand?
Well, the thing is that the Europe, or the UPC territory to be precise, but it is possible to have pan-European injunctions in the future. We come to that. And China and the US are certainly the three most important economic areas in the world. Of course, in terms of costs, there's a huge difference between the US and the UPC. The UPC is simply, to put it like that, much cheaper. Although the UPC, if your patent has been validated in enough countries, attracts or will affect, to put it like that, more people. Concerning China, the number of cases that we have in China, that's simply enormous. I read a statistic that there are like 40,000 infringement cases in China each year, and that's just enormous. And compared to the, well, let's say maybe 200 cases that we'll have this year. Last year it was 164. Compared with speed, as far as I know, the Chinese courts are very speedy, so you have a decision in 1 year. In the UPC, it's comparable. If there's a counterclaim for revocations, you can have it like in 15 months or so. In the US, could be different. Of course, in the US, you have the discovery and you have juries, and we don't have this with the UPC. So from that perspective, Chinese and UPC procedures are maybe more comparable. But let's say how to put that. The UPC is still a young court, and so we have to see how influential in the future UPC decisions will be, let's say, worldwide. At the moment, we see a clear trend away from national litigation, at least in Germany, towards the UPC, but that's, of course, within Europe. We have to see how the impact of the UPC will be outside of Europe.
Yeah, we come to an important, interesting case later that maybe highlights this new trend away from the US, maybe into Europe. But we come to that later. If we think of a company with global sales, like the large players we are representing, for example, Europe and the US, and manufacturing suppliers in China, maybe, in which situations would you say the UPC is your most powerful tool, and in which situations might the US or China actually be the more strategic battleground?
That's a good question. To be honest, I would always always consider filing at the UPC, simply because, let's say, the bang for the buck, to put it like that, is pretty good. And especially because the UPC is rather quick, it also can be used as a negotiation tool. It's whether you should file in the US instead of the UPC or the other way around, or at the UPC instead of China, that of course depends a lot on the circumstances of the case. I mean, but in my opinion, once you have substantial sales in Europe, you should consider the UPC. And I think in the future, the UPC case number will increase simply because of that reason.
You've already been involved in several UPC cases now, and one with me. That was really cool to work together. Thank you very much. Looking at the last 12 to 18 months, is there a case, a decision, or development that you find particularly noteworthy, and something that really changed how you think about the UPC litigation or how companies should prepare?
Well, I mean, the most important case by far that I've been involved in is, of course, the Syngenta Visumiagro case. Simply because it's now a landmark case. It was even mentioned in the annual report. It is important for several reasons. At first, it was one of the first cases where the Court of Appeal had stated that if you have infringement in one country, that's usually enough for an injunction for all countries. That's one. The other one is that we had, it was so that we had analyzed, the patent was about a composition, and we had analyzed a sample that was obtained in the Czech Republic, which is no UPC country, but then later the product was sold under the same name in Bulgaria, and it was interesting whether this is sufficient. Yes, that was affirmed. There are some other aspects which are important. For instance, that also the Court of Appeal again appointed here more or less that the EPO's inventive step approach is similar, and confirm that there's a pointer needed if you want to combine certain document, or as it is in a decision, the mere chance that you get a certain information out of the document is not sufficient. For me personally, what I found super interesting about this case was not so much the surprising outcome. To some extent, that was not surprising, that was expected. But in this case, we had several oral hearings, but we had 2 oral hearings at the appeal stage. And in both cases, we were asked a question by the presiding judge, once by Klaus Klabinski, and in the other one, more importantly, Jan Kalten, that we would have never had expected. And then you have like 20 minutes to come up with the sufficient answer, which we were able to manage. So that's something that really made me think. So you should go into oral hearings with a team. It should not be too much of a big team, because in German we say, zu viele Köche verderben den Brei. And in English, I think that's the same. It's called too many cooks spoil the broth. I hope I pronounced that correctly. And that's true. But you should have, let's say, 2 or 3 people maybe, so that one can, on the side, work on this surprising question, whereas the others carry on with the oral hearing. And that was really something that I still remember out of these oral hearings. And in the end, it went pretty well. So of course, I can now talk here all relaxed. But you do get, your heart beats faster when you're there. for a while.
Yeah, right. But there were maybe also other cases that you found noteworthy.
Yes. Well, to be honest, the most important case of the last, let's say, 12 months is not an UPC case. It's the case by the CGEU, the Bosch Siemens Haushaltsgeräte wie Electrolux. And that's going to be a real game changer for European IP. I think we have not seen everything here. So you mentioned before there's an interesting development because somebody sued BMW at a German court. It's Landgericht München I, the regional court of Munich, for a patent infringement in the US, out of US patent. And it was argued that this would be backed by Bosch Siemens Haushaltsgeräte wie Electrolux. Well, of course, we don't know what the court makes out of that, but simply that someone tries that tells you that this is not the end of the story. But within the UPC, we have already had injunctions issued for countries outside the UPC territory, even outside of the EU with the UK. So that's a development where we have not seen yet everything, but that's a true 100% game changer.
So in this decision of the European Court of Justice, just to briefly summarize for the people who don't know among the listeners, the court decided that the UPC or maybe other courts also in Europe can rule on patent infringement that happened outside the country that the court is responsible for, right?
Yes. And so before that, we used to have the so-called Gat-Luk regime, which meant that if you sued somebody out of a patent, for instance, let's say in Germany, and you said, I want injunction also for, let's say, France, and the other party said, I doubt that the patent is valid in France, then the court could not issue injunction for France. But now the CGEU has overturned this. And if I make just one comment, the reason why the CGEU is competent here is the so-called Brussels regime, Brussels 1A, which deals with civil law cases throughout Europe. That's not only for patent law, it's for like general civil law. But there's a small section on patent law in there, and the CGEU was asked by a Swedish court, because the case was in Sweden, to give some guidance about cross-border injunctions, and the CGEU more or less overturned its own Gat-Luk regime, which was roughly 20 years old. And now it is so that the court, if the defendant is domiciled in that country, principally can issue cross-border injunctions. We will not go into the details. That could be another IP Fridays where all of that is explained. It's really interesting. And
so the defendant has to have a seat in the country where the court is responsible for.
Yes, but if there's a group of defendants, then it can be that there are also defendants which are outside that country. And we have a case where one of the defendants was in Hong Kong, can also be affected, provided that they all are one group. And then you have, it's called an anchor defendant. If the anchor defendant is in the country where the court is domiciled, then also cross-border is possible. The importance for the UPC is simply statistical. I mean, there's a higher probability that the defendant is somewhere in the UPC country simply because there are 18 of them. But in principle, this is for pan-European, and we have had a case where Landgericht Munich 1 or maybe it was Oberlandesgericht. I don't know. In the pharmaceutical case, they issued a pan-European injunction for 20 countries. So that's not limited to the UPC. But of course, it is important for the UPC, and we will see tons of requests in the future.
Right. And so just to clarify, it doesn't have to be the headquarter of the defendant, just any office or any official location. Right?
That's how about to be decided.
Let's see.
Let's see. I mean, if the headquarter is in Europe, then also subsidiaries outside of Europe can be affected too. If the headquarter is not in Europe, then we have to see.
Let's see what the courts make out of it.
Yes.
So many patent owners and in-house counsels are wondering, does the UPC largely follow the case law of the EPO, the European Patent Board of Appeal, or is it starting to develop a clearly independent line? What is your impression so far, both on the substantive side, like novelty and inventive step or obviousness, and on procedural issues?
Well, the procedural law is, of course, much different. So the UPC had its own procedural law. But concerning patent validity, in my opinion, and I've given a presentation recently, and I will have another one in February in Hamburg, I call it nothing new under the sun. So in my opinion, the EPO and the UPC, the case law is really, really similar.
Right.
And the thing is that, in my opinion, the error bar between, especially when it comes to inventive step, between investigating one document is higher than possible different approaches. So, I mean, if you follow the problem-solution approach, or some people said the UPC doesn't follow the problem-solution approach, it follows a holistic approach, whatever that is, still you have to read or interpret a document and see what's really in there and what's not. And in my opinion, if you ask one court and then another court, the difference between interpreting these documents, let's say the error bar in that is much higher than the error bar between different approaches. So, but I mean, in that's for inventive step. But if you look at the other grounds of opposition, here, I mean, the UPC even follows the APO verbatim. So the gold standard, I mean, they don't cite the decisions, but they copy them. So, I mean, if you look at the decisions, the gold standard, it's all over the place, and it's for novelty and it's for added matter. So even the, let's say, rule-based approach, or what I called Hilbertian approach, is somewhat followed by the UPC. So that's actually very interesting. But if you ask me, there's also a reason for that. If you allow me 1 minute to discuss that.
Sure.
The thing is as follows. The UPC has, let's say, the issue, one could say the problem, that all it handles has been granted by the EPO. There are no patents before UPC that have been granted by national patent offices. So if the EPO wants to deviate from EPO jurisdiction, then the UPC must be stricter, because it is not possible to be more lenient, because simply then there are no patents that reach the UPC. Of course, it could be that the EPO did a mistake, and some examining division was generous, but that's gambling then. But so, as from this perspective, the EPO's approach is the most generous approach you can get. The thing is that, of course, that the UPC has no reason to deviate from the EPO's line, simply because then there are no patents left, or less patents than before, and maybe then people would just opt out.
Yeah, we talked about added matter. We talked about added matter and a recent decision about added matter that even reached the appeal stage, where the appeal was even stricter than the EPO when applying the rules of added matter, and that probably puts a lot of headache into the heads of the US patent professionals who are already have a big headache with added matter in the US, and now
especially for added matter. I once talked with a practitioner from America who said, "Well, we hope that the UPC will get away from intermediate generalization." No chance. We have had cases where this was affirmed. Yes, you're talking about the recent case, the Sol versus v. Expert Klein. And here, a patent was revoked for added matter that had been granted like this by the EPO. And so this is what we see. If you want to somehow see in advance how the UPC will handle your revocation action, then you should think, what would the EPO do? And then you probably will come to a good result. Of course, in the end, it can be different. I mean, sometimes the UPC will consider something inventive that maybe in a parallel EPO case, the EPO will not, simply because the reading of a document is different. But that's it's daily practice. But the approach, I mean, in my opinion, is the same.
Right. What does it mean in practice for enforcement and defense strategies? Can you give one or two concrete examples where knowledge of the EPO case law is a good starting point, but where the UPC has maybe surprised you or clearly taken a different route?
No. They take the same road. No.
Okay.
I have to be honest, I've no real case where I would say, oh, wow, the UPC has taken a totally different approach than the EPO. That now really surprises me. No, to be honest, it's if you want to give an estimation how the UPC will rule, think of what the EPO would have done.
Yeah. If you look across the cases and divisions, what trends do you see in UPC practice? For example, regarding timelines, preliminary injunctions, the handling of validity attacks, and the interaction with EPO oppositions or national proceedings. What patterns are emerging for companies that they should really be aware of?
There, let's say the rule of thumb is that, let's say, the top 5 ones. And I don't want to be rude for the other divisions, but simply there's not so much case law. But the top 5, which means that the top 4 in Germany and The Hague, their line at the moment is, of course, cum grano salis, pretty similar. They all try to be on time. They all try to be really careful and really diligent in their decisions. There are a few trends, maybe where there's some deviation. So for preliminary injunction, I see a differentiation between the local division of Düsseldorf and all of the other ones, because in Düsseldorf they are of the opinion that 1 month is urgent. If you wait longer, then it's not. Whereas more or less all of the other divisions think 2 months is okay. On the other hand, Düsseldorf, except for one outlier from Milan, but this was issued by the standing judge, Sangranata from Brussels. But if you take this aside, then only the Düsseldorf division has issued ex parte preliminary injunctions so far. All other divisions, at least to my best of my knowledge, have not done this. I have co-organized a conference, albeit 2 years ago, where we had Judge Pichelmeier from the division of Munich, and he said, well, he cannot really imagine a situation where his division would issue an ex parte. And he said, at the UPC, you have two procedures. One is fast, and this is the, let's say, main procedure, and the other one is very fast. But you don't have the ex parte, more or less. So that's one difference. The other difference is, and we had a recent case, in Munich, if you have to amend your patents or file auxiliary request, it means you lose. It's very interesting. Some other divisions have allowed auxiliary requests. In Munich, they don't like this. So this is one difference concerning preliminary injunctions. What we see, or where we don't have a line, to put it like that, is concerning equivalence. We have seen only one division confirming equivalent infringement, and that is The Hague. And they have simply used, not lost, they have used a test that they have obtained from Dutch law. Whether this will be affirmed by the Court of Appeal, I don't know. In the first case, later it was then settled, so the Court of Appeal will not rule on that. The other one is just very recent, so we have to see what the Court of Appeal makes out of it. Interestingly, there is a third case that issued just a few weeks ago where equivalent infringement was at least on the table, but the Hague division did not use this test. So I don't know what happened in the meantime, or why they did not apply that. We have to see there's a movement here. There is a very interesting decision by the Mannheim division in which they said it would be good if, let's say, a pan-European test that simply does not take any of the national tests could be found. But yeah, in this decision, the Mannheim division did not develop such a test because that was not part of the decision. But they have, let's say, at least pointed this should be a goal. We have to see what comes out of that. But concerning timeliness, one last mark, it's interesting that usually before Düsseldorf there's no interim conference. They don't do this, which of course gives them a few months. At the other divisions, usually you have interim conferences. Whether this is good or not, I don't know. Actually, to be frank, I do like the idea of the interim conference. But on the other hand, that's up to the court. And if the court is well organized, you may well have skipped it.
Yeah, the parties maybe get an idea where the court is headed when they have interim conferences. But yeah.
To be honest, that I would not say.
Okay.
These interim conferences I had so far, questions were asked and issues were raised, which later in the main oral hearing were not discussed at all. I found that pretty surprising. I don't know. So you cannot judge from the interim conference to the main one. We have to see. But of course, the interim conference helps to clarify certain issues, which of course you can do in writing if you want.
Yeah. When looking at the behavior of the parties that are involved in the cases in UPC proceedings so far, whether they are enforcing or defending, what do you see are the most common mistakes you see in UPC litigation strategy of these parties, and what would a well-prepared company do differently before the first statement of claim is ever filed?
Oh, you don't really want me to answer that question, don't you?
I want to.
Of course, the main mistake that companies make is they don't hire me. That's the main mistake. No, serious. So it's. I think it's very hard to judge at the behaviors of parties as an outsider. You don't know the full picture. You're not involved. You don't know if there are any parallel proceedings, so you cannot act as you want. I've had this before. So let's put it otherwise. What is a good idea if you are at the UPC? So the good idea is that you should be aware that this is front-loaded and this is quick. And so if you receive a case, if you're sued, you have 3 months for your reply and your counterclaim for revocation. To be honest, because I've had this, 3 months is manageable in my opinion, but only if you don't waste any time on not necessary things. So if you receive an infringement suit, it means you have to act immediately. So you have to have a strategy set up within the next, 2 or 3 weeks or whatever, and then you have to act according to it. And if you change everything in the meantime, it means that you may fail. This is the one thing. And the other thing is that everything is front-loaded. So you will have a really hard time getting new documents or new attacks or whatever in once your first chance to do so is over. I mean, there are at some cases the divisions were a little tolerant or generous. So for instance, in this one case I just mentioned by The Hague, where they did not apply this equivalent test, here the patentee had brought up equivalent infringements only in their reply, not in their initial statement of claim. And of course, the other party had objected this, but here the court had no problem. Maybe they had no problem because they saw no equivalent infringement. We don't know. But usually it's really hard. And divisions are here pretty strict. So even if you have filed documents, but you come with a new attack based on these documents that are already on file, for instance, in the oral hearing, that can be regarded as late filed. Or if you, this is out of my case, and in here there was a book chapter that had been filed in first instance, and then in the appeal stage, of course, thankfully, to put it like that, I don't want to be rude, it was the other party that relied on another book chapter out of the same book. And then we said, no, this is late filed. They could have done this already in first instance, and we got it right. And also, there's case law, for instance, that if you come up and say, well, we have a inventive step attack out of D1 plus D2, and then later you say, we want to combine D2 with D1, can be late filed. So that's an issue. On the other hand, and that's to some extent a little disturbing, although it fits into the picture, we have had a recent decision where as well as a revocation action, where the plaintiff, here the party that wanted to destroy the patent, filed like 50 inventive step attacks in their first brief. And then the division said, no, this does not work. Please either cut that down or put them in hierarchy. And in the end, they did not consider all of them. Well, in the end, we don't have an ex officio investigation for the UPC, so the division is allowed, in terms of case management and fair proceedings or whatever, to say, okay, dear plaintiff, you must limit yourself. But on the other hand, if you are asked to put everything on the table at once, We have to see what comes out of that. Maybe this is an extreme case, I don't know, but we have to see.
Yeah, I have the feeling that even at the European Patent Office, it's quite front-loaded now. And if you don't introduce all documents that you want to use later in the very beginning, then maybe it's late filed later, and maybe it's even more extreme at the UPC now, right?
Yeah. It is.
Right. Suppose someone from a company is listening now and thinks we might actually be exposed at the UPC, or perhaps we should actively use it against competitors. What would you consider a sensible first step for such company before any specific dispute erupts? And looking 3 to 5 years ahead, how central do you expect the UPC to become in global patent litigation compared to the US and China?
The second question is easier to answer. In that regard, that I would think that the UPC will become more important. And that's something that I simply expect. I mean, at the moment, if we have 200 cases this year, that's, well, I don't want to be rude again or disrespectful. Even at the UPC, there was an interview with François Bouton and Klaus Gabinski, where the UPC said, well, we are happy with the caseload. But if you compare these case numbers with, I don't know, in the USA, there are, how you count it between 4,000 or 5,000, and in China there's 40,000. Of course, 40,000 is, let's say, where of bounds, maybe, but even compared to the US, 200. Klaus Gabinski, if you're listening, don't be upset. 200 is nothing, in my opinion. So I think we will have, let's say, 4 or 5 times as much cases in the near future. It's inevitable. And then, of course, the importance of the UPC will rise. Whether in like 5 or 10 years, companies will choose the UPC as like the go-to first venue, or rather have it as parallel, especially if you're a very important case, then you always have parallel US and UPC proceedings. I don't know. We have to see. I mean, the UPC would be well equipped for that because simply the territory it covers is big, and Europe is still an important economy. We hope that it will continue to be so, but it is. And the UPC proceedings are just excellent. For a company. So, I mean, if you are a defendant, or if you fear that you are being sued, then a protective letter makes sense, definitely. It is so that at least in Düsseldorf, there is a possibility that you might be sued ex parte. So if you have a protective letter, which of course should have some quality, otherwise that might backfire, should be filed. Protective letter, at least when it comes to official fees, are not really expensive. And there's a system that ensures that the court reads these protective letters before they do anything. If you want to sue somebody before the UPC, then you should be aware that you should be well prepared, and that you have all documents that you need already at hand. Because as we just discussed, it's really hard to bring in new information once you file it. But it is possible, and that's becoming, I think, more and more popular, at least if you look at the case law, to have inspections. Not only at trade fairs, we used to have trade fair inspection cases already, like in the first weeks, but also at company sites. And we from our firm have had one of these cases. So that's something you should keep in mind. If you're already being sued, So if you have your infringement suit, the statement of claim on the table, then you should know that the clock ticks, and you must prepare yourself. But the thing is that I don't think that the UPC procedures are unfair to defendants. I mean, if you've done your job right and you have, let's say, a pretty good revocation action that you bring on the table, then the other party has only 2 months either to prepare their reply and all of the auxiliary requests. And the thing is that here, it's not like with the EPO. With the EPO, your main problem is, are those auxiliary requests still, or will they overcome the objections, and are they patentable? With the UPC, it's also the issue is, do you still infringe? Because if you have an auxiliary request that is patentable but you don't infringe, well then, you may have saved your patent, but you lost the case against the infringer. So that's even more difficult than with EPO proceedings, and there is only 2 months for that. So then the clock ticks for the other side, and that puts some pressure on the other side as well.
Yeah, thank you very much for this really great interview, Aloys. You have a nickname in our firm, the Walking Encyclopedia of the Unified Patent Court, because you already wrote so many books about it and have dealt with UPC for such a long time. What would be the best way for people to get in touch with you?
But yeah, I have an email, so you can write me an email. So right. That's a good way to contact me. I'm as you might have noticed, I like to hear myself speak. So I'm a frequent speaker and of course, if you happen to be at one of the conferences where I'm speaking, for instance, next week Monday in Hamburg, then you can just come up to me and ask me something in person. But yeah, I think email is the best way, maybe.
All right. Thank you very much, Aloys.
Thank you. And it was a pleasure to be once again on the IP Fridays. Listeners of your podcast may know that a few years ago, when you were not even in our firm, I already gave a presentation, or we had a discussion, put it like that, on right. the UPC already, where it was pretty speculative. Now it's really great to be on your podcast again, now that we have this thing in place and running. Thank you.
Thank you for being back.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.